An arraignment?
I do, but
You ready?
Judge, I saw a roll from yesterday for some reason. He was called back, Mr. Pollard, Pollard.
Oh, that's right. Yeah.
I think we spoke to him because he kind of.
We don't, well, what I asked yesterday is whether bond petitions had been filed and I didn't see them.
Okay. So,
That's why.
okay.
Oh, it was a trespass.
Yes.
I guess I assumed it was the DWI.
No, the trespass.
No, he was a walkthrough. He received a PR bond in court and he didn't receive conditions with pre-trial. I'm not sure if he ever got state conditions. House number because
Oh, yeah.
9 minutes.
262 0.
Yeah. So the conditions should have been not to go back to this is the one where he allegedly goes to the city of Houston property and allegedly
Right.
takes something or other.
That's correct.
Right. So the conditions should have been, don't go back to this property, don't pick up any new cases, no contact with any of the complaining witnesses. I don't think they ever got filed. They never got done and he never signed it. So that's what we need to do. So what we'll do is he here now?
Oh, he's here.
Great. So we'll just have him sign it and then he just goes to, so can you file, no going back to the location, no new cases, no contact with complaining witnesses. And then if I remember correctly, he didn't have a license either.
I'm not sure.
Do you mind running his driver's license? Because
He says he doesn't drive.
does or does not?
Yes.
He does. All right. As long as he has insurance as well, then he can drive. But
But he can hear you. Yes, he said yes.
okay, great. Yeah. So just want to file everything that as soon as it comes up, we'll have him sign it and then he's free to go. And then it'll be waived for the next couple settings.
Perfect.
So,
Thank you, Judge.
okay. Thanks, Marcos.
Thank you.
All right, Judge, the next arraignment is page 8, Cobb. Come on up.
All right. Good morning, Mr. Cox. Sir, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay. Oh, it looks like you're also charged with possession of marijuana and a felony threat to disclose intimate visual material. Okay. It looks like all three out of the same transaction. So, all right.
Are we ready, Judge?
Yes, ma'am.
Officer met with complainant who stated she was in a previous relationship with defendant. She stated they broke up in April of 2026. Since ending the relationship, defendant has called or texted complainant every day after she repeatedly told him not to. The complainant provided calls, texts, social media, emails, Cash App, and other channels of communication where the defendant is trying to contact the complainant. The complainant provided evidence where the defendant threatened to post photos and personal info online, specifically videos of the complainant through Instagram, Craigslist, and OnlyFans. The complainant provided a fake Instagram account with a picture of her. The complainant stated the defendant was the only one who had that picture. The complainant provided texts where the defendant stated, "Answer me or I'm posting it," and other similar threats. The defendant continued to threaten the complainant with texts like, "You'll hate your life more and more every time you don't answer this phone. I know you work tomorrow. I'll be outside. You got till 5 to text me or I'm ruining everything. Your job, your car, whatever I can. This shit gonna get ugly. I'm gonna start killing people." While speaking with the defendant, deputies detected a distinct odor of marijuana emitting from his person. They confirmed he had active warrants and requested execution of them. Incident to his lawful arrest, they conducted a search of his person and located a package labeled strawberry milkshake containing a green leafy substance in his possession. It looks like he had a total of 0.09 ounces.
Was this when he was arrested? Then they were.
Yes, Judge, that's my understanding from what I'm reading here. As they were searching for an incident to arrest.
So I see that he has prior criminal history, and
All right, we are 5 minutes in, and we are already deep in the weeds. This guy, Mr. Cox, is facing 3 charges from 1 transaction: harassment, possession of marijuana, and a felony threat to disclose intimate visual material. That is a stacked docket. But here's the kicker. Listen to Judge Fleischer. He's already talking about a violent history and a GPS monitor with a 1,000-foot radius. He is not playing games today.
looks like violent history. Is it the same complaining witnesses as well? And it's pretty recent, 2023.
It looks like the same complainant on the felony that's pending.
Yeah.
And then not the same complainant for the past criminal mischief judge. And if there are any others out of county, I'm not sure if it's the same complainant or not.
Got it. Does he have any other criminal history that you see out of county?
No, Judge.
Mr. Cox, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to make sure that you're not using by testing you, and I will test you like crazy to make sure. You are also ordered to undergo and have a GPS monitor on you, and I'm placing a 1,000-foot radius that you're not to go within either of the complaining witnesses where they live or where they work. I'm going to protect my community at all costs, and if that means putting you in jail at a high bond, I will do it in a heartbeat. Do you understand me? You are not to be in possession of any weapons or go anywhere near these people. Use of third parties to attempt contact. You are not to have any direct, indirect contact. I'm telling you, you endanger my community in any way, it's going to go really badly for you. You understand me? You will be tested 40 days from today. If you test positive for alcohol or any illegal substances, including marijuana, I will revoke your bond. You currently have 3 open cases. You pick up a 4th, I will go bananas on all of your bonds. So, do we know, did the felony court restrict internet access? They did not. All right. So at this point, we are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset. You'll meet with Veronica for your bond conditions. After that, we're going to reset your case. You will get the GPS monitor today. It is right. So link onto it so we know. It is your responsibility to charge it. It is your responsibility to maintain it. If I find that the battery goes dead, so will your bond. You understand? All right, come on.
All right, Judge, page 16. Winsler.
Good morning, ma'am. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay. Yeah, please.
On Tuesday, June 9th, 2026, Officer Smith was making a left turn in the 2900 block of West Bay Area Boulevard in Friendswood, Fergus County, Texas. While making the left turn, the officer observed a dark gray passenger car not displaying the front license plate stop at the red light at the intersection. The vehicle was facing northbound. After making the left turn, the client made a U-turn and caught up to the vehicle at the intersection. The vehicle was in the inside lane and would stop past the designated stopping point at the intersection. The client ran the license plate displayed on the vehicle through NCRC to CIC, which returned to a gray 2017 Hyundai passenger car with an expired registration of June 2019. The client got behind the vehicle, and the vehicle made a left turn at the next intersection. They conducted a traffic stop. Upon making contact with the driver, there was a strong odor of an alcoholic beverage emitting from the vehicle. The driver's eyes were watery, and her speech was slow. She was identified by her Mississippi driver's license. The officer asked her where she was coming from. She advised her home in Lake City, and she was traveling to buy cigarettes at a gas station. She was asked to exit the vehicle. And she advised that she had approximately 3 vodka cranberries around 4:30 p.m. Her eyes were watery, her speech was slow. There was an odor of alcohol coming from her person and breath. Standard field sobriety tests were performed. She had a 4 out of 6 on the horizontal gaze nystagmus, 4 out of 8 on the walk and turn, and 2 out of 4 on the one leg stand. Then the DIC was read to her, and her breath results came back at a 0.097 and a 0.111.
Ma'am, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
She did, sir.
I mean, is it eligible? As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I want to randomly test you. If I find that you're using alcohol or illegal drugs, your bond will be revoked. You'll go into custody. Because this is a second offense, I'm now placing another restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I send notice to DPS in Austin so that every police officer in the state knows if you're caught driving a vehicle and that vehicle doesn't have an interlock, they're going to take you to jail, and then you're in violation of these bond conditions. Do you understand?
Yes,
Ma'am, do you have the ability to hire a lawyer?
I do not.
How do you support yourself?
I work.
What do you do for a living?
I'm a field agent.
And what kind of income do you make on a monthly basis?
It's contract work, so it depends on the jobs available. No more than $3,500 a month.
So tell me why you can't afford a lawyer.
I'm a full-time single parent. I take care of my kids with no supervision.
So it's based on the poverty guidelines,
Yes,
right?
sir.
The federal poverty guidelines that you have to be making 15,800 and less a year.
Yes, sir.
I can have you fill out an application, but I need to know everything about you, whether you have any other household income, including boyfriend, girlfriend, spouse. And then I'll take a look to see whether you qualify. I need to know everything about you, what kind of car you drive, how many cars, stocks, bonds, mutual funds, and then I'll take a look to see whether you qualify. Deputy Williams will give you an application. I'm going to have you sign a receipt, and then we'll have you take a seat in the jury box, man.
Thank you.
Whoa, hold on a 0.097 and a 0.11 on the breathalyzer. That is well over the legal limit. But here's where it gets interesting. This is a second offense DWI, which means Judge Fleischer is not just slapping her wrist. He is mandating an ignition interlock device. That's the breathalyzer you have to blow into to start your car. And he's sending notice to DPS in Austin, so every cop in the state will know. That is public humiliation wrapped in legal consequences. But watch her face. She's a single mom making $30 to $100 a month.
Please.
All right, Judge.
Hold on. On the trial case,
Yes, Your Honor.
do we know it's,
I thought it dismissed one this morning.
okay, so it's getting dismissed. Got it. Okay. All right. So yeah, just if it's being dismissed, just,
Yeah, and I let the defense know as well.
okay, great. Got it. Okay, Victoria.
Ready?
Yeah.
All right, Judge, page 20, Ramirez, come on up.
All right. Good morning, Mr. Ramirez.
Good morning, Your Honor.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor.
Okay.
On June 8, 2026, officer was dispatched to Harris County, Texas, roadway. Officer first contacted the defendant who said he had been assaulted by his girlfriend, who he had been in a dating relationship with for a month. Defendant showed video of victim throwing coffee and kicking him. Defendant declined to pursue charges and that he felt pain. Victim was visibly distraught and said that she wished to pursue charges and felt pain. Witness stated that he saw defendant bear hug victim but saw nothing else. Defendant was arrested. Victim had visible injuries, including a red mark on her right shoulder, a red mark on her right side of the face, and a cut on her left forearm. Defendant had a bruise on his right arm.
So the allegation is that he threw, did you say coffee?
That she threw coffee at him while they were driving, while he was driving the car. He pulled over, they got into an argument, they're fighting, he's getting out of the car, asking him to get out, and the fight keeps on going. Defendant has sent us some videos of the altercation.
What did he do to her,
We,
if anything?
we threw her down to the ground and held
Was
her
that in
down.
response to him, her throwing coffee to him?
Coffee and trying to kick him.
Is it hot coffee or is it cold coffee?
It looks like a cold coffee because it's in a clear plastic cup.
It says here intentionally and knowingly, recklessly causing bodily injury to the complaining witness by striking the complainant with the defendant's hand. Did you say that or no? Because I didn't hear that.
I did not. I did not.
Is that there or no?
On the videos that I saw.
No. No. Did you say that there? Yes or no? Is it in there?
Say that.
All right, I'm going to find no probable cause.
Thank you, Your Honor.
All right, Mr. Mears, good luck, man.
Thank you.
All right, Judge, next is page 23, Sosa. Come on up.
This also,
Sosa, correct. Come on up.
have an ear infection, can't get it. Oh,
Good thing you got 2 ears.
okay.
Clear, sir.
Come on.
Right.
Mr. Sosa, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 8, 2026, at 5:39 p.m., officer was dispatched to a gas station on a report of suspicious activity. Defendant was inside the gas station. Defendant was insulting staff, exposing himself, and masturbating. CW stated defendant exposed his penis and started grabbing it in a jerky motion. CW found this offensive and wanted to press charges. A strong odor of alcoholic beverage was emanating from defendant's person.
Do you have any other criminal history that you see? Mr. Sosa, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand? You are not allowed to go back to this gas station. If I find that you go back, if you pick up a new case, then likewise into jail you go. No more PR bonds, like I said. Okay. Sir, do you have the ability to hire a lawyer?
Okay.
How do you support yourself? Are you working at this time?
I was laid off, November 24th. I've been trying to get back in since.
I think that's a long time. You still got to eat, bud.
Well, I'm a senior systems engineer, kind of getting older. Just the name of the game,
Sure, happens to all of us,
right? So we still actively,
but life doesn't stop. You still got to eat, you still need clothes, you need to get a job, right?
right?
So-
I mean, I go in slow, but I was able to get the opportunity.
Okay, so Deputy Williams will give you an application. I need to know everything about you as far as how you're living, how you get money, how you eat, and then I'll take a look to see whether you qualify. I don't know who you have in this life, Mr. Sosa, but if you're a danger to my community and I have to put you in jail at a 10, 15, 20, $50,000 bond, if you don't have anyone to pony up that kind of money, you'll be stuck like Chuck with me for a long time. Do you understand? There are no mistakes in this life. There are choices, and you either make a good choice or you make a bad choice. You understand?
So am I guilty?
I don't know.
Okay,
Presumably, you're not guilty at this moment.
I'm not guilty. Yeah.
Correct. But I'm putting bond conditions on you to ensure that you don't pick up any new cases.
Right.
We will give you a lawyer, assuming you qualify. We'll take a look at all the evidence. Then we'll put a plea bargain agreement on your case. You decide whether you want to take it. You don't have to take it. If you don't take it, at some point, we will set your case for trial, and then we'll have 6 people take a look to see whether the evidence matches up. The evidence will point to whose side is correct. I don't know. I wasn't there. There might be video, there may not be video. I don't know.
Right.
But the evidence will point to whose side is correct.
Okay.
That's just how it goes. Please.
All right, Judge, top of 25, Swede, come on up.
Every time you violate conditions, the same thing will happen. If you violate conditions again, I'm going to triple, quadruple, perhaps quintuple the bond. You're at 10,000 now. It's only going to go way up. Do you understand, Mr. Swede? I'm not going to play this game with you again. The bond conditions will not change. They will remain the same. And if you want to continue to play the game, I'm going to be here for who knows how long, but really, do you understand? We are going to reset your case to give you time to hire a lawyer. I'm going to have you sign for all the conditions, and then we'll see you in 30 days. When you come back, please have a lawyer.
All right, Judge. Next is page 27, Walker, Morris. This one's a CHA.
Hey, on Swede, GPS and a scram, please. And then curfew, the 9 p.m. to 6 a.m. What was your last name, ma'am?
Walker.
Walker. Ms. Walker, do you have a lawyer today?
No, sir.
Tell me what you're doing about that.
I've been getting, stuff in the mail, calling and trying to file as
Okay, so your case is about 88 days old. I'm not giving you much time. You have 2 weeks. At that point, I'm fast tracking you to trial. Do you understand? There are a gajillion and one lawyers in Harris County. Some people just don't want to pay for a lawyer because they just don't want to pay for a lawyer. You don't qualify. So you need to hire a lawyer. 99% of them will put you on a payment plan if you ask. It's just a matter of you going out there and doing the grunt work to find one that fits like a shoe. You know, don't go to Gucci, don't go to Fendi, don't go to Louis Vuitton, go to what you can do. Please.
I just wanted to make sure we start having the hearing later today.
I don't know. I haven't seen Kobe.
Okay.
And then is a defendant? Yeah, the defendant's here. So yeah. Yeah, I'm assuming. Anyone else?
That's it, Judge.
That's it. Okay. Mr. Lester.
Morning, Judge. How are you, sir?
Morning.
I am here today concerning the following case number, 2614 8440 1010.
2614.
Correct?
Yeah.
8440 1010. That would be Horta Quiroz.
Okay. Do you just want to reset?
Well, Your Honor, my client would like to enter into an agreement and plead, and so I want to put the paperwork together. So yes, sir. Could we have a reset?
Are you saying he wants to just do a time served, or does he want to do the PTI program, or what?
The PTI program.
PTI, okay. Can you take a look? Is he approved, or does he need a mitigation plan? Please. Horta is the last name.
Doesn't say Judge, it's a first driver's license and it's a home.
No, I mean, Does he need, is it above a 15 or is there an accident?
No, Judge, it's 0.109.
So he's not going to need a minute.
Accident, it was, driving facts was just speed.
So it looks like you're probably not going to need a mitigation package, just the application will be sufficient.
This would be probably just, approved by court chief as well.
Okay, you think so, or?
Yes.
Okay, they're going to approve it, so really all you need to do is the application. Once you do that, have them come in and we'll send them to go do a TRAS and then you're basically home stretch, you know?
Sounds like a winner.
July
I appreciate,
first.
We're looking July 21st to the 23rd-ish for a reset.
excuse me, Your Honor, that was July. Been heck with technology today. This played havoc with me. For next week, July 21st,
Yeah, 23rd or 21st to the 23rd.
any day there's going to work for me, Your Honor.
Okay, we'll put you on for the 23rd then.
Sorry, you blacked out, Judge. What day did you say?
23rd.
23rd?
Yes.
Okay, July 23rd. We'll get
Okay,
everything
man.
ready and be ready to go.
Have fun.
God bless you. You have a wonderful day.
You too. Take care. Hi, Stace. Come on up. Good morning. What's up?
I'm here, Miss Kimberly Sullivan.
So,
I don't know if the state is gonna continue to try to correct this, but it's like, oh,
yeah, it's time that we, put up.
Kimberly Sullivan.
Sullivan is last name.
Well, let's see that every place, so I don't.
What? At 190 days? It's not even been attempted?
That's not good.
Okay, I'm going to set up for a 10-day trial setting, really. If she's missing videos and there's no rip done, we'll give you guys 10 days. If everything's not in within 10 days, then. Yeah, all right, set it for a 10-day trial, or not trial, but a 10-day discovery hearing setting.
Okay.
Okay,
All right, thank you.
yes, ma'am.
Hey, Bertrand.
Sure.
Pushing Trent Morris.
Okay,
Morris, the state got the ribbon this morning. I need to reset to do mitigation factor on.
okay, we'll give you a week.
Can I get 2 weeks, Your Honor? You need to just, start the process today.
It's 190 days old, though.
Yes, Judge, and there's no surveillance, there's no way for the state to prove this.
But why are you coming to me at 190 days old and tell me there's no surveillance?
Prove their case, Your Honor.
No. If you're at 140 days and you're missing evidence, come to me and I'm going to put pressure on them to get their act together. And I'll give them a 10-day, discovery hearing setting. If they don't have it, then nothing comes in.
Yes, Your Honor.
You know what I mean? But you're coming to me at 190 days when really come a lot earlier next time. At this time, I'm ready to go to trial. So,
And we requested it every setting.
but if you don't tell me, I don't know.
I'll approach earlier.
Right. At 140 days, if you're missing, let me know and I'm going to put pressure on them.
Yes, Your Honor.
I just want to make sure that I heard the name correctly. Is it Trinidad first?
Yes.
Yeah. So they're missing.
We're not missing anything.
Oh, you're not missing. You just told me that you were missing something.
Yes, we were missing the rest. There's no surveillance on the case at all because it didn't capture the incident. So we're
Okay.
waiting.
All right. I was under the impression that when
Against the
you
other.
say they don't have it, it's because they do have it. They just don't. Okay. So discovery's complete other than the rip.
It appears so.
Rick was done this morning, Your Honor.
So they got the rip.
This morning, yes, and that's why we wanted to do a mitigation package.
Okay. 2 weeks, it's clear trial. I'm not giving you any more resets after that. All
I'll
right.
make sure it's submitted before the day.
Got it. Don't submit the day before you come to court too.
I'll make sure our office submits at least 2 days before.
All right. Thanks, Sebastian. Ready?
I have just a party on the docket.
Hartley? Harvey?
Yeah.
Jail or bond?
Bond.
Okay.
The name's on felony court. Might be good today.
MIA? Okay. Let me see, what is it now? Oh, he's got an open felony warrant.
Yeah.
So, let me see, what's the bond?
My bond is $200.
Yeah, okay, so, yeah, he's bond denied on the assault of a public servant. Okay, so I'll set it at 5,001. Okay. Thanks, bud. I'll reach out to you if he should come in. What's the problem?
He told me that I need a meeting on that.
Hey, grab him.
Now you're gonna have. The rest of this all ridiculous. Womp womp.
I'm already very upset with you, Mr. Swede. You're on bond for a serious case, and you're out there acting as if you're not on bond for anything, as if there's nothing going on in your life. And now on top of it, you're disrespecting our bailiffs. That's not cool. And if it happens again, I'm going to have a contempt hearing and you will be facing 180 days in jail. Do you understand? I will make a docket notation of everything that has transpired here, but everyone that comes into this place, you treat with respect, dignity, no matter who they are, no matter what gender they are, no matter their position. You understand? This isn't a place where you pick up people. If you want to do that, go to a club. This is not a club. Okay, please. Hey, if anything should happen again, just please let me know and we'll take the appropriate action. I've documented everything that's happened now and the multiple instances that he's been in the jury box acting up as well. So. Carlos, need me?
Yes, you are.
What's up, buddy?
Good to meet you, Judge.
Hey, you too.
Well, I'm glad to be here, Your Honor. I'm sorry I wasn't here yesterday.
That's okay. I understand.
And we were almost in one. But they filed a different case and we're free.
Cool.
You know, I did a lot of research on this case yesterday and I had a very good discussion with the chief. I presented her with some issues that I think just stopped off bad.
Okay.
I offered some, I told her I was bad case law for that. So we were going to respectfully ask for time so that the state could evaluate what we were talking.
What's the last name again?
Gunnels.
It's an old case, right? I mean, I'll give like a day or two so that they can figure out, but I mean, it's over 200 and.
It's fine, Judge. I think we've been trouble.
Yeah, I mean.
If we get that case off in defense and also we'll be doing our own research, I make some.
Yeah, let's put it on for Thursday. And then just see, our division chief should be here within hopefully sometime, but I get it. I mean.
Just a little detail, Judge. Thursday, I'm supposed to be in Brazos County. Is, and Friday, I'm supposed to be.
Friday, it's on.
Yeah.
There's no court Friday.
I know everybody's trying to avoid tomorrow because of the.
I'm okay with tomorrow. I mean, I'm
The
open
world
to work.
jumping off doesn't bother me. I think that's where,
Oh, is tomorrow World Cup day?
Yes, there is a game.
that's what all the other courts we had cleared their delegates.
Sure. Yeah, I get it. We're not doing tomorrow either.
Yes, sir.
Would Monday work, Judge?
Well, you know, Your Honor, Thursday, I guess if you don't mind me appearing on Zoom.
Yeah, that's why we have it.
So we can see what the options.
Just have him prepared in the event that it goes south so that he knows.
Yes, Your Honor.
You know?
So I'm assuming Thursday, there's a state agrees with us, and then we'll, then of course, we may not have to worry about it.
Right.
If the state does not agree or they think there's a challenge, then I'll have a decision from Mr. Granados if we work out.
Come up, Granados.
Yeah.
But he speaks English, right?
Yes, he is.
Okay.
And we can have a decision whether or not we're gonna work out the probation that the state is offering, or if we could set it for trial.
But I get it. I want you to understand something. I have enough drama in my life. I don't need any more. If you want to set this case for trial, I'm happy to set for trial for you, but I will not take any more plea bargain agreements after that day. Thursday is your last and final reset. We set cases for trial at 180 days. Your case is over that. So you need to meet with your lawyers, make a decision on what you want to do. If you want to take probation or if you want to take whatever they're offering, great. If you set it for trial, we will go to trial. I will not accept any more plea bargain agreements after that date. You understand?
Yes, sir.
That is Thursday will be your plea bargain deadline. So we'll just have you sign a reset. Your lawyer, Carlos here, may be in another county, but I'm allowing him to appear via Zoom. In the event that we do a plea, just be ready to go through the paperwork so you know, be ready. That way we can do the plea, just get in and get out, and we can just have him sign everything, right?
Okay.
If you want to set it for trial, great, we just have him sign a reset, but after that time, there's just no more pleas. Okay?
Yes, sir.
Okay,
Thank
thanks.
you very much, Ron.
You got it.
Have a good day, sir.
You too.
This way.
Can I borrow you for one more thing? We have to do a cite and release, please. I have to give you a cause number and then we have to determine whether there's PC or not. It's 262-4691 on a Heinz. He's charged with driving on a suspended license. If you just want to read what happened, I'll find PC or no PC.
Officer observed the defendant operating his vehicle while using his cell phone and not hands-free. The insurance was also unconfirmed when running the license plate. Defendant's vehicle was a gray 2002 Dodge Ram. Officer activated the lights to conduct a traffic stop on the vehicle. Defendant exited the main lanes to service road. Officer then contacted the defendant, who's the driver of the vehicle and sole occupant, and asked the defendant for his driver's license. He provided the officer with his driver's license number. The officer ran his driver's license, and it was not eligible and currently suspended. Due to the defendant not having insurance, the driving while licensed and invalid was enhanced. And
Okay,
that's all.
all right, I'll find PC exists. Thanks. We will issue a warrant.
Morning, Your Honor.
Morning.
Hey, first,
Please,
I have Gregory on the dock.
jail or bond?
Bond, he wasn't ordered to be here today. It's a non-file setting. I'm not here on PC.
On 4/18/2026 in Harris County, Texas, the officer responded to a terroristic threat call on CW advised that he had received threatening messages from a friend at school in which defendant advised that he wanted to take him out, referring to CW, and that, quote, "I wish I did." The table and took us pulled out. And that the defendant was trying to find where CW lived so he could take him out. If he couldn't do it at school, the defendant admitted he sent the messages to the friend.
So he sends text messages
Yes, sir.
to the friend. And what do the text messages say?
That he wanted to take him out, and I wish I did at the table and took us both out. And the other one said, the other one just said, oh, and he said basically that he was looking for, that the CW was looking for the defendant's address. Defendant was looking for CW's address.
Are we supposed to assume that that's threatening? Maybe he wanted to take him out to dinner.
Furthermore, Judge, if I may, it says here in the DIBs, the victim explained to a fine on this date, a friend named John forwarded the threatening statements. These allegedly
Did Judge Fleischer just crack a joke? Maybe he wanted to take him out to dinner. That is savage. But let's break down what's actually happening here. This is a PC hearing, probable cause. The prosecution is trying to prove that a text message saying, "I wish I did take us both out," is a terroristic threat. And Fleischer is clearly not buying it. He's using sarcasm to signal to the prosecutor that this case is weak. But here's the legal reality. Even if he finds no probable cause, this guy is still sitting in jail.
Written statements were sent to complaining witness, Your Honor. They were sent to somebody else.
She said something different. I don't know.
Well, that's what it says right here in the
Is that right?
right here.
I mean, it doesn't even matter. It really doesn't matter. Okay, I'll find new PC.
Thank you, Judge.
Yes, ma'am.
Maybe please.
Yes, ma'am. Counsel.
Yes, sir.
Hey, good morning.
Is that
Okay, what is the last name again?
Chavez?
Oh, he picked up a new felony case. Oh, no. So tell me, he's a violation of a protective order. Is this the same, in the felony case, is the same complaining witness as in this case?
No, Judge, yes, they did,
So what happened in this new case, if you don't mind?
felony, on 2/17/2026, the officer in his town places observed a motor vehicle traveling
Reset. Oh, they're resetting the date.
traveling at a high
Hold on.
rate of speed. Past the officer, a traffic stop was conducted, driver's license check on defendant. Found an active, protective order with CW, the passenger of the motor vehicle. Defendant advised he knew there was a.
No, not in our case, in the felony case.
Yeah, this is.
This is the felony case?
Oh. Okay, sorry.
Why she lives your night, so home affairs, right? Accusing him of making public their public,
Accusing him what?
making public, transcending their name pictures.
So making public nude pictures.
Officer investigated an unlawful disclosure of internet visual material. Officer spoke to the principal who stated that there was a photo of a current student performing oral sex, which surfaced on Instagram page of the school on 4/10/2026. CW stated that she was advised by several students that an Instagram page, quote unquote, DIHS page confessions, contained a post of a picture of CW having oral sex with defendant Chavez, her ex-boyfriend, while home alone with him, and he had recorded it. CW stated that around November 2025, they broke up. Defendant Chavez found out that she was friends with defendant JJ and sent him a copy of the video thinking her and defendant JJ were in a relationship. CW stated that they made a police report of the incident, but did not have a case number, nor did they hear back from the police department they made the report with. CW stated that a picture from the video was posted on social media and she was told defendant and he was the one who uploaded the photo. CW stated that defendant JJ could have sent the photo. Defendant JJ gave a non-custodial interview where he stated that he was not aware of how defendant Aguilar received the video, and as he did not share it with them, defendant JJ stated.
I think we're good. Yeah, we're good. Mr. Chavez, I'm going to find that you violated the conditions of this court. You are a danger to my community. I'm now revoking your bond and you will go to jail. I'll set the bond at $10,001. Okay, you will go into custody now.
Thank you.
Thanks. Darla,
Yes, Judge.
hey, what's up?
So this is a follow-up on the PTI mitigation packet we submitted last week. I have not heard
Rangel.
back from the state. Oh, sorry. Yes, I'm sorry.
That's okay.
Approaching on Rangel.
Page 21. Yes, we have the application in the basic packet. We just need to take a look at it.
Okay, so Corinne should be here momentarily, right?
Or there's another sheet coming down. Is she, Corinne's online?
I don't believe Corinne is online, but Lindsay Pearson is supposed to come by 11 o'clock today.
Yeah.
So let's do this. I'll set it for a day or two. Let's set it for Thursday, Darla, to see.
And I'll send it to Karina, so.
Yeah, and then we're just, as always, you can zoom in, but your case is 225 days old, so I'm not doing a long reset. So let's see what they say. If yes, then we can just have her come in Monday and do a TRAS.
I believe a TRAS has, no, it wasn't. We talked about that last
Not been
time.
done yet, so.
Okay. Yes, that's why she had to be there this time. So can my client's appearance be waived on Wednesday?
Yeah,
Judge, you said Wednesday or
Thursday. Wednesday's a
sorry.
fee day.
Thursday.
Yeah, okay. Yeah.
Right. I will have been married 25 years on Thursday. Fun fact you probably don't want to know.
Wow. That's great.
Yeah. Okay.
Yeah. Okay,
So
we'll see
my
you then.
client's appearance can be waived on Thursday, and
Yeah.
if she's approved Monday, she can come in and
Yeah.
do her walkthrough.
Yeah.
Sounds good. Thank you.
Okay, thanks.
That's time for a case review.
Of course.
The first one is gonna be 2-5,
Okay,
2-2,
okay,
3-4.
okay.
So this probation is about to expire. He hasn't paid his court costs, that's the thing. So he has $4,778.
Yeah, but now, he has time to go to India and all this other places, and yet you just don't want to pay. No, it's your warrant.
Extension warrant? Okay,
No, it's your warrant. We've already, no.
okay.
I told him that I didn't want any issues, and there's an issue.
Okay.
It's your warrant.
And then the next one is 249,
Okay,
4967.
6-7,
249, 49670.
4967.
He's on that today. The last is a silver.
Yeah, okay.
He picked up a new car.
Where's Silvernail now?
I don't think it was brought, so we're rolling up our Mara.
I remember somebody.
It was 10 days ago. Yeah, when we amended his conditions and we picked up a new charge for violating on the board.
Okay, it is what it is. We'll get him when we see him. Hi, come on. Hi, yes, ma'am. Good morning.
I am approaching on Miss Mesler. Lovella.
Okay,
Judge, Miss Mesler, bond condition says that she must have an interlock device. She told me that she does not have a car.
she picked up a DWI 7 days ago. So whatever car she was driving, that car needs an interlock.
Yes, Judge, she said she was using a friend's car. She drives her roommate's car every twice a month or so.
It still needs an interlock.
Okay. So
Anything she has access to that she's going to use or whatever, she needs an interlock on it. Doesn't matter.
would a portable device?
No, no.
Okay, so anytime she drives, then she.
Yeah, yeah, yeah. It needs an interlock.
Okay.
Sorry. Yes, ma'am. Yep. Hi, Ms. Pearson. Sorry, they've been waiting here a long time. So, you guys, if you want to come up, let's just make the announcements. And then, thank you for helping us out today. Guys, we are going on the record now If you need to talk, please go outside. If you're going to use the phones, please go outside. Oh, well, we were. She should be out momentarily.
Anyway, that's.
Terry, that's right. All right. Are you ready?
Yes, Judge.
All right. We're on the record in cause number 2611816, the state of Texas versus Kiwana Carey. Today's date is June 16th, 2026. It's approximately 11 in the morning. And guys, I'd like you to, with the state going first, please announce yourselves for purposes of the record.
Lindsay Pearson for the state. Carla Northby for the state.
And for the defense.
Kobe Bose for Mr. Carey.
All right. We are here to have a probable cause hearing. We initially had one, I'd say, was it maybe like a week ago, would you say?
About a week ago.
And we decided to postpone it to have a full-blown hearing so that everybody could get into what they needed to do to ensure that there is probable cause to make a fair and full ruling. So I guess with that said, state, you want to go ahead and
Yes, Your Honor. So to just start by reading what the probable cause was. So on June 5th, 2026, officers were dispatched to an assault in progress, an unknown weapon check at a unit at an apartment complex in Harris County, Texas. The call slip had advised that the defendant was hitting a woman and was in the bathroom of the location. Officers had knocked on the door and a female opened the door and was visibly crying or was visibly distressed. She advised that the defendant was in the bathroom. The female stated her and the defendant had a verbal altercation. Officer observed no visible injuries, but did observe her to be visibly distressed. Officer told defendant to come out of the bathroom and show him her hands. Officers unholstered a taser and pointed at the bathroom door, and defendant attempted to run past defendant. Officers attempted to detain defendant, but defendant continued to pull away from officers and placed both arms under his chest. Officers got control of the defendant and with assistance of another officer handcuffed defendant. So the officers were attempting to conduct an investigation into the assault and asked the defendant to come out, at which point he attempted to run out of the residence.
he's charged with terroristic threat though, correct?
Yes.
Did you say that there was a terroristic threat in that?
That is a,
That's the other case. The new case is an interference case.
Oh, I'm sorry. Okay, so, and I gave you the wrong cause number for purposes of the record, then the cause number is 2623705 for the interference. I'm sorry. So for purposes of the record, he was initially charged with a terroristic threat from March of 2026, March 23rd, 2026. And now on June 5th, he was subsequently arrested for interference with the duties of a public servant. The initial call that was placed to 911, did you say who made that call?
it was the female's child, Your Honor.
Okay, so a child.
Yes, who reported, and this is on the CAD, there was a assault in progress. Mom's boyfriend was attacking mom. There was an unknown weapon, or they didn't know if it was a weapon. The pulse of tasers, a busted female lip, and there was threats to kill the female.
Okay. And so the interference that you're alleging arises when?
So officers arrive at the location and attempt to detain defendant. They are at the threshold of the residence, ask him to come out with his hands up. He comes up, they lower their weapons right when he puts his hands up and attempt to detain him to conduct an investigation into the assault, at which point he attempts to run out. Of the
Okay.
residence.
So that's what let's see what the information says real quick.
Just pulling his arms away is the matter means.
Right. Okay. So it says did then and there unlawfully with criminal negligence, namely pulling his arms away, interrupt, disrupt, impede, and interfere with M. Jones, a peace officer, while M. Jones was performing duty, and exercising authority imposed and granted by law. Okay.
Yes, Your Honor. So when they were attempting to detain him and they had his arms, that's when he attempted to run out of the residence.
Okay. Is there anything else that you guys want to add? Anything else that you want to do, say, witnesses?
Yes, so when the officers arrived, the defendant had initially complied. He had his hands up, was putting them behind his back. And when officers started to attempt to detain him and put handcuffs on him, that's when he attempted to run out of the residence.
Okay. Anything else?
The only other thing I would add is in the offense report, it does say that he did pull his arms away from the officer when he was trying to detain him.
Okay.
A couple of things, an important distinction, because I think initially we heard he came out of the bathroom and attempted to run, and that's why the officers put hands on him. And then it was clarified that he was complying, and the officers put hands on him. And then I guess the representation is that he tried to run, and then there's a takedown. A few things.
Well, I think now you're saying as when he was being placed under arrest is when he's moving his arms away.
When he was being detained.
Okay.
And that's going to be a point of contention. I think their position is that this was a detention. Our position is that this was an arrest and there's no EC for the arrest. I'll kind of explain why that matters legally and what supports that. But importantly here, and I can call a witness, I can show the court the video, and I intend to do so just so the court knows what's going on. And I think that's part of why we're here, so you're
sure
actually see what happened. They arrive on the scene, and we don't contend that it's not okay for an officer to come investigate when they get a call from a child that says someone's being beat up. Clearly, they're allowed to be there. They're allowed to investigate. And they do some investigation. They come to the door, one cop. What we didn't hear from the Dems, we heard that a taser was pointed at my client. Initially, it's 2 firearms, which you'll see in the video. And then one of the officers says, "I'm going less than lethal," and pulls out his taser. That's left out of the Dems, of course. But it's an important fact that goes to whether this is an arrest or a detention. And they call the lady out, the lady who had been the subject of this 911 call. They ask her, "Hey, what happened? Are you okay? What's going on?" She said, "Everything's fine." And I don't want to misrepresent what says, but I got it for, she says, I'll just tell the court, nothing's going on. I'm totally fine. Everything's okay. My baby over-exaggerated himself. That's discussing the 11-year-old who called. So those are the 4 statements that they get out of.
We are deep in the weeds now, and this is the most important part of the entire docket. This is the case where Mr. Carey was tackled by police, his face busted open, after a 911 call from an 11-year-old. The defense is arguing this was an unlawful arrest, not a detention. And here's why that matters legally. Under Texas law, you cannot interfere with an unlawful arrest. If the police had no probable cause to arrest him, then he didn't commit interference. The defense just pointed out that the officers lied to their supervisor about what the complaining witness said. That is huge.
The subject, this complaining witness initially, she tells the police that he's in there taking a shit. That's just the facts. That's what's told to him. The police then respond by saying, "Hey, the suspect's going to be locked in the bathroom." Well, that's the representation they make on their. So there's, of course, no evidence at all at that point that he's locked in the bathroom or that he's barricading himself. They created that out of thin air. The complaining witness then responds, "No, he's not." Meaning, one, he's not the suspect, and he's also not locked in the bathroom. This isn't a barricaded situation where you need to start justifying your use of force. The officers respond by telling the complaining witness, who they're there, I guess, to protect, "Get over there." Eventually, they put hands on her and actually sort of move her out of the way. They physically push her as she's trying to tell them, "There's no reason to go in my house. Please don't create an issue where there's not one." They tell her, "I'm not going to tell you again. Get away from your own door." The Officer McDaniel pushes her out of the way, says, "Go over there." And he says, "He's not using the bathroom. I know he's not." So now, of course, we don't believe the complainant. "Stay back there. I'm not going to tell you again." Jones approaches the door. Breaks the threshold through into the house with his gun pointed. McDaniel has his gun out, and then he says, "I'm going less than lethal." Then he pulls out his taser. Eventually what happens is they tell Mr. Carey, "Come on out. You're taking too long. What's taking so long? Come on out." This isn't a situation where they're saying, "Hey, Mr. Carey, you just need to come on out. We want to have a conversation with you. We need to ask you some questions. You're being detained. You're not under arrest." Like if this happened at my house, I think that's probably what would happen to me. "Hey, Mr. DeBose, we just need to ask you a few questions. You're not being arrested." We see that all the time whenever there's a detention. And of course, what the law allows is a brief investigative detention to collect more facts. But what it doesn't allow here is an arrest, and that's what they went to. The reason we know, and the case law tells us what differentiates an arrest from a detention, the use of force. In this case, not only are 2 guns out and then a taser, but they go to physically put their hands on him and put him in handcuffs. By their own admission, what they're doing at that moment is putting him in handcuffs. They never tell him you're not being arrested. That's one of the factors. We often see that in these cases. So you're not being arrested. I'm just handcuffing you for everyone's safety. You're not being arrested. That doesn't happen. In fact, much the opposite. Come out, show us your hands, turn around, put your hands behind your back. These are all the telltale signs of an arrest. I'll point out that the video is going to show that Officer Jones comes up to Officer McDaniel about 20 minutes into this and says, I just Mirandized him and got a statement. Well, we all know because he's been taken out to the car, they read him Miranda. The officer obviously thinks that he's in custody for the purposes of needing to read him Miranda, which goes to the idea that this was an arrest. I subpoenaed Officer Gonzalez here today. He recognized the subpoena, sent an email saying he could accept it by email. He's not shown up. But in his use of force report, in the offense report, if we're citing that, he says, I was there, I was assisting with the arrest. He uses the term arrest, and he's the 3rd officer who actually puts the handcuffs on. So from his point of view, it was an arrest. You're going to find from this video that the officers initially say, we're going to call the DA's office and try to get a resisting charge. Resisting what? Resisting arrest. Again, their subconscious judgment as experts that they're placing him under arrest. Now, the DA's office doesn't take resisting charges because this wasn't an arrest. Now they're taking a position that this was just detention. But this wasn't just detention. The amount of force used, the fact that they go hands-on with him, he's coming out saying, what did I do? What did I do? Well, if this were a detention to investigate, this would be the back and forth. But we just want to ask you a few questions. No, that didn't happen. What happened is they put hands on him, and then within about 3 or 4 seconds, he's taken to the ground. His face is busted open. He's seen by HFD because he's all beat up, and that's the situation. It's a physical tackle takedown. You're going to find from this video, the officers pretty proud of their actions. They're fist bumping one another. So that was a near perfect takedown. They had a lot of different discussions about it throughout the course of this video. And something that I think is important because it's going to be in this video and it goes to the credibility of this officer. It's very clear that the woman tells him, he asked the lady, it's Officer McDaniel, where's the Mr. Carey? Where's the guy? Where is he? And she says to him, he's in the bathroom taking a shit. I think that's pretty well established. But when McDaniel talks to his supervisor, Magnum, to justify his use of force, you know what he tells her? He tells her, I asked the CW where he was, and she told me that he's not here. He lies about what the CW tells him to his supervisor. And why does he do that? He does that to try to discredit the CW because they're going to try to take the position that she's lying about not being hit. He's not even willing to be honest about what the CW, who he is there to protect, said to him. And he does that to protect himself because he's being asked about his use of force. It's just an outright lie. And there's a few other lies there too. When he describes to his supervisor what happened, what he says is, so he's locked in the bathroom. He's lethal, I'm less than lethal. I can't remember if I pointed my taser at him, I gotta review the video. That's all fair. This is how he describes the encounter. He starts coming out, starts like closing the distance. So we both holster up and tell him to turn around. He just tries to bolt through both of us because Gonzo is standing inside and eventually taken down. The timing of this is very important because under that set of facts, the idea that Mr. Carey came out of the door and tried to bolt through, well, sure, you might be justified in that moment in putting your hands on him to detain him. But in the actual story, where he's coming out, complying, putting his hands up, asking what he did, and you hit your hands on him to arrest him first, and then take him down to the ground, that's a much different tale than what he's telling to his supervisors. Now, the video will obviously tell the truth about what actually happened here. What we're arguing is that in order to have interference with public duties, it has to be a lawful and authorized public duty. You can't resist an unlawful arrest, but that's because resisting is using force against an officer. And the law says we don't want you using force against an officer, regardless of whether it's a lawful arrest. But for interference, they have to prove that this is a lawful action taken by the police. And for that reason, it matters whether he's just doing a lawful detention, or in this case, what would be an unlawful arrest. And what happens here is that he comes into the door and does all the things associated with an arrest. Which leads us to our next question. Does he have probable cause to arrest? Well, what do we know? We know that when they arrived, they had a 911 call from a child. And then some of the things that they've been told the 911 call, they end up not seeing when they arrive. They don't see physical injuries. They write that in their own report. There's no sign of physical injuries on her. And then all of her statements suggest that she had not been hit. Eventually, this charge is declined by the DA's office for obvious reasons, because there wasn't PC at that moment.
So wait, what was declined?
The assault family member was declined because there was no PC to arrest him for assault family member at any point in this encounter. And if there was no PC to arrest him, then the arrest is without probable cause. It's not a lawful arrest. And so you can't, you're interfering with something that's not lawful or not authorized. Therefore, they don't meet the elements.
But under the stress of the moment, you don't know who's coming out of the bathroom. You don't know if they're armed. You don't know who you're dealing with. So immediately, and is it plausible that initially when they're doing a detention, they put someone in handcuffs just to see who they're dealing with first? And then perhaps when they can assess the situation, okay, all right, everybody's calmed down, you know, everybody's fine. We'll let them out and then we can have a civil discussion.
I think the case law is pretty clear that just putting somebody in handcuffs doesn't transform it into an arrest. And I'm not trying to make that the test. And the case law is clear that there's ways, we see it all the time in DWI cases and in assault family members where someone's put in handcuffs. And what helps that not be an arrest for the police officers is the way that they do that, which is to say, hey, I'm putting you in handcuffs here. You're not under arrest. That's a factor in there that they let the defendant know he's not under arrest. And that's important because most people, when they're put in handcuffs, would believe that they're under arrest.
Yeah, I mean, I would agree that, you know, when you see, most times you'll see, you know, hey, look, we're just kind of.
It's the amount of force that's used. And the courts have said things like the way that people are being talked to. I mean, the nature, the sound, the tone of their voice, the entire totality of the way that it's conducted. Look, when you see it, you know whether that's an arrest or whether that's a detention. And look, what is a detention? It's for the purposes of investigating. They don't do, this isn't, hey, come on out, let's ask you some questions. It's, we've already made a decision that you're going in handcuffs, and the minute you move, we're going to throw you on the ground. I don't think they have PC to arrest, and I think it clearly, according to the case law, the way that they conduct it, and you'll be able to see the video and all that, will agree with me, I hope, that this is an arrest. But I'm not trying to say that they can never put someone in handcuffs, but that's not what happened here. The case law on this, whenever we read it, it'll usually say things like, well, this wasn't a case where they pulled out their guns on him and then used physical force. Well, this is our case. All the factors in those other cases where the courts say, well, this isn't an arrest because this doesn't exist, we have those factors. I'll point out the officers seem to even have thought it was an arrest themselves. Again, reading Miranda, talking about the resisting arrest charge, things of that nature. I'd like to introduce the video just for you to see.
Sure.
If we're okay with that.
Do you have any, you want to reply?
And just like that, no probable cause. Judge Fleischer just threw out the interference charge. That is a massive win for Mr. Carey. But look at how Fleischer handles it. He's not gloating. He's giving Mr. Carey a speech. Living as a young black man, it is very difficult. That is a judge acknowledging the real world outside the courtroom. He's telling him, you won today, but you're on bond, and you need to live like you have a halo above your head. This is the kind of judicial wisdom that makes Fleischer so compelling.
Sure.
Well, Your Honor, at the time the officers arrived at the location, only information they had was what they got from the call slip, which was that there was an assault in progress and that there was threats made to kill the female that's in question here. And that the child who had called advised that the defendant had put the female in the bathroom. They arrived at the location. They saw that the female was physically distressed. They noticed tears on her face. Her eyes are swollen, and you see that in the video as well. They asked the defendant to come out. He takes a little bit to come out. They don't know if he has a weapon or not. And when he comes out and he puts his hands up, they attempt to detain him. And at that point, he tries to run out the door.
We dispute that fact too. I mean, I think
let's see it.
Yeah.
I
don't think that's even true, but we think it's an arrest. And I'm not saying they didn't have reasonable grounds to detain him. I think there's enough going on here that these officers are entitled to do that. But a detention and arrest are two very different things.
But In the course of that detention, did he interfere with that detention?
It wasn't a detention. This was an arrest. That's the point. Because it wasn't a detention. What they did was an arrest. It was tantamount to an arrest, so his actions were in response to an arrest. We can't speculate on what he would have done with a lawful detention because one wasn't done. This was an arrest. And I think he just needs to see the video, but if y'all are okay with it.
Yeah.
Okay. I'm gonna play, and I'll bring it up for Judge. Make sure this internet's working. Okay. And just so everybody knows what I'm playing, this is the body cam of Officer Tristan McDaniel, and I'm gonna play this from, I don't know, the 2:52 mark, which is as the officers are approaching the door.
Thanks. I'd say it was. I called just Boston. Buzzy has a lock in the back. The big call. They go to the big call. What's wrong? Hey, just go over there, all right? Stay over there. It's the police!
Nothing going on. Look, I told them that the whole thing, they got misunderstanding. My baby was here. I'm glad he got misunderstanding. You right here, I just went to go get him from by here. That's all. I'm totally fine. Ain't nothing going on.
Take a look around, make sure everything's okay.
Yeah, everything's okay.
Okay, here, come talk to us real quick.
Yeah. I don't know, because that's my cousin's apartment.
Come over here.
I keep saying, because I don't want to think about my baby exaggerated itself.
We're already here.
Yeah, no, you told me fine. I was crying and stuff. And he
Where's your boyfriend?
He's taking a shit.
Hey, no, hold on. He's in the bathroom.
Yeah, he's taking a shit.
Stay out here.
Oh.
Look. 14th and 18th. Suspect's going to be locked in the bathroom inside you. Hey,
no, he's
go over
not.
there. Listen to me.
Sir, can y'all not make a problem?
Look, your eyes are very red and watery.
I was just crying right now. I was just because I was upset and I've been on the phone with my mom talking to her and stuff. I was upset. I was. When I'm upset, I cry, sir.
I'm telling you to relax.
Baby, they coming.
Go over here.
I'm just letting them know y'all he's using the restroom.
He's not using the restroom. I know he's not.
Yes, he was.
What's wrong?
We just came back from the store.
Stay back here. I'm not going to tell you again.
I'm not going nowhere.
Come on, Alex. Yes.
Hey, just come out. You taking a shit.
Come on, Alex. Yes. Don't take so long. I'm going to Leslie. Hurry up, brother, please. Turn around, bro. Turn around.
What did I do?
Put your hands behind your back.
He's not doing what I do.
Put your hands.
No, I didn't do nothing. I'm telling you, ain't nothing happened. No, ain't nothing happened. My hand, brother. Y'all clicking my hand. Ain't nothing happened. Ain't nothing happened. I swear ain't nothing happened. We're just fussing, bro.
Get her up.
I didn't do nothing to my face, bro. We didn't do nothing. Look, I'm fucking body. I was just coming outside. Because I knew how y'all is, bro. God damn, nobody was just to y'all. God damn, nigga. I'm telling y'all, I ain't got shit, nigga. Nigga, I ain't got nothing out, bro. Bro, y'all doing all that in front of my charge. Come on, man.
Do you want to add anything?
Your Honor, based on what the officers knew from the call slip and when they arrived for officer safety, they had their weapons drawn. They did not know if the defendant had a weapon. From their understanding, the defendant was locked in the bathroom and there was an assault occurring. which when they made contact with the female, they could see her do business.
I get it, but clearly there's no exigent circumstances. There's nothing going on. There's really just no need for really, yeah. All right.
They were just attempting to conduct the investigation.
Okay. All right. All right, I'm gonna find no problems.
Thank you, Judge.
All right. That said, Mr. Carey, come up.
Judge, we still on.
No, off the record. Sorry.
That's okay.
The terroristic threat is not against the same complaining witness, no. I don't know if it's probably a good idea to kind of separate them for a while, you know? I like to craft conditions to ensure that nothing else happens. I don't want to have to put you in jail. You know, the thing is in today's society, living as a young Black man, it is very difficult. And when you get into a pissing match with people who have the power of arrest, and when you get into a pissing match with, you know, it's a very dangerous game. The idea is that we craft conditions sufficient so that there are no more further issues. So for the time being, I'm going to order you not to have contact with this person. I just don't want any further issues. You understand? Do not have any weapons. Do not pick up any new cases. No contact with the complaining witness in this case. I'm going to find no probable cause, but really, just, it's not hard to be nice. If you have problems with people, just really, you're on bond and you need to be living like you have a halo above your head. You understand? Okay. All right. Thanks, guys. Please don't leave. We're going to have bond conditions created and then.
Terroristic threat?
Yes, ma'am.
Oh, interference.
I'm sorry. Interference. Interference. Well, Toby, I don't know if I can really do that since I'm finding no PC, you know? I don't know if I can do no contact on that person, you know? Because I don't know if I have jurisdiction to do that because I'm finding no PC. Just please warn him accordingly.
I think my understanding is they're not independent together. It's a no.
Okay.
Another girl.
Well, regardless, tell him.
The girl from the video, he goes, no. I was like, I feel bad now.
Just be careful. Yeah. Okay, man. Hey. Do I know you?
At times.
How are you?
Good.
Good to see you.
I had 6 inches shorter hair last time I was here.
Me too. Touche. What's up, bud?
Not too much. How are you?
You know, living the dream.
I am here covering for Andrea, which is to say, I know.
Okay, give me a second. It was, she's right over there. It's Garcia is the last name.
There we go. Something about a rip has been done.
No, I put conditions yesterday and we had just reset the case. We didn't put her on for today, did we?
She's on our docket today. I don't believe there's a rip pending. It's a prostitution case.
Okay, so.
No, yeah.
I think I talked to the coordinator who told me that there was
We didn't put her on for today. We just did a normal reset, right?
Hernandez?
Garcia. Remember from last night, she didn't want to initially sign the conditions and then she ends up signing the conditions.
Which Garcia are you talking about?
Andrea could have fixed it.
Top of 10.
I believe it's.
Top of 10.
There we go. Yeah, going for Andrea.
Oh, no, I'm thinking the wrong person. I'm thinking the wrong person. I'm sorry. I'm sorry, ma'am. Just take a seat. I'm way off.
She was supposed to have sent me a name. I think she was right.
You know, it's the jail case. The dude's charged with assault. That guy. That's Hernandez. That's it is. It's Hernandez.
Excellent.
And we did get a rip done on.
Excellent.
Earlier this month on the 10th.
And we decided to dismiss it?
So no. Well, that's on them. But the issue is that the bond is set at 10,000 now.
Okay.
The allegation is that he makes a statement allegedly that I'm going to take flight and I'm going back to wherever I think it was El Salvador. And so I said, I will give you a bond reduction, but I want the passport first. So I know that you're not going to take off.
How do we provide you the passport if he's still in jail?
Well, family,
Yeah.
they have the white sheet, the chit that you would sign. And then it's because from what, I don't know, but I'm just saying, that's not my purview, but
Yes, Judge. I will communicate that to him. Who would we turn it into?
the registry here with them.
Excellent.
When you get it, let me know. I will make a docket notation. We'll take it into the registry. When the case is over, we will give it back to you guys to give back to him.
Thank you, Judge.
The only other thing I will tell you is that the other problem she had is she didn't want to physically accept it because she's had, I guess, issues in the past of taking property from clients, and then it's a whole hell of a problem trying to get it back to them. So
Yeah. She has a gun that I lent to Andrea because a client had picked it up from my office. Thank you, Judge.
For sure. Hi, Charles.
Hey, Judge, how are you?
What's up? You made it.
I made it. Matthew Taylor, Your Honor.
Okay.
It's 178 years old, so it's right there. We have an offer, the discovery's in. I'd like one last setting to kind of
Let me see how old it is.
178.
How long do you want?
2 weeks.
Okay. Do you have an offer on the case?
Yes, Your Honor.
Okay. Is he here now?
Yes.
Just, Mr. Taylor, come on up.
Oh, I thought it was a hallway.
I don't know why Miss Garcia came back again today. I thought we were just going to reset.
That's what you're talking about. Yes, you wanted to play this game.
Oh, got it. Okay. Mr. Taylor, we set cases for trial at 180 days, and you were at that point. We are giving you a final 2 weeks. Between now and then, it would behoove you to go with your lawyer to figure out what you guys want to do on this case. That is the plea bargain deadline that you have. At that point, if you don't want to accept it, you don't have to. I'm going to set your case for trial, but I will not accept any more plea bargain agreements after that time. We said it, you will go to trial. Do you understand? Okay, do you have a discovery's complete and there's an offer?
Yes, Your Honor. Let me confirm. Yes, Your Honor.
Cool. Okay. All right. Good luck. We'll see you guys in 2 weeks.
Have a great day.
You too. Hello? What's the last name?
It's an off-target matter,
Oh, okay. What's your cause number?
262-3529.
Oh, yeah.
So she got the scram this morning. When she went to go get the interlock, she does not have her driver's license, and so they told her to have me come swing by again and find out what she wants.
Doesn't matter. I mean, she still has to get the interlock anyways.
Okay.
When someone doesn't have a license, when they pick up a DWI, they will nevertheless still generate a number for them. So because otherwise really, we'd never be able to do anything with anyone. I mean, how many people have nothing? So there is still a number, and she still has to get the interlock so that we know if she gets into a car, she's not going to have alcohol on board.
Okay.
So,
I can address that today. They wanted to turn about Docket on Thursday.
yeah, well, that's because we're showing that, as far as I know, she doesn't have the scram. She doesn't have nothing. She's way past due. She was supposed to get a 6.5 or 6.16. As far as I know, she doesn't even still have it.
616, I got the case 611.
Yeah, and we can confirm that she got the scam device this morning.
Okay. So tell her she has until Thursday to get the interlock. By then, if she doesn't have it, she's got to be here. Okay.
Address exclusion. She lives on the same street as the person that she was going to see. This is DWI, so I don't have a CW here. They live on the same street, so that she is within that 1,000 foot natural.
Well, tell me about the complaining witness again, because I don't remember.
It's part of the BDR that she is within the exclusion zone.
We have so many cases, I just don't remember everything.
Or Reyes?
Reyes, yeah.
So based on the witness stated he has a protective order against the defendant.
Say it again?
The witness stated that he has a protective order against the defendant. The defendant was driving by his residence as well as coming up to the front door.
Okay, I guess let's modify it to 200 feet. Okay. Just, I don't want her going anywhere near him. Okay? Okay, thanks. Okay. Hey. Okay. Waive the signature. Yeah, always. Yeah. Huh?
So I talked with the officer and because of how close the homes are, he said that it would not be in violation. Recommended distance would be.
How close do they live?
Yeah, 2 houses away, like there's 2 houses in between. I can show you the map if you can see it, but.
Does it really look like 50 feet?
I'm not sure, I can show you.
Okay, yeah, I guess. Hey, state. So on this case, they're saying that they live 2 houses apart. So even at 200, she's still going to end up violating.
We make it 500 feet? Is that too?
Did you say 500?
Yeah.
No, even 200 will still be in violation because they live 2 houses apart. Okay, I guess, I mean, how does she know 50 feet? Is she able to, I'll put it on Google Maps and see that it's 50 feet between her house and the other one?
The officer sent me the map and it shows the 2 different, like the Vix's home and then the Ryan's home and where.
Okay, so I guess do the 50 feet, right? If he goes within 50 feet, we know that she's going near him. And then at that point, just really,
So what happens, Judge, if that person drives in front of the other person's house?
well, that's the problem is they keep,
Right, but are they, that's funny. I'm just being nosy.
yeah, so yeah.
Because
Go the other way.
we usually tell them they have to enter their neighborhood through the.
You can go the other way.
And what if they Andrea?
Yeah.
If it's a dead end street, there is no going the other way.
It's not a dead end street.
Okay, my street is a dead end street, there's only one way in.
Yeah, well, thankfully this not. Okay. Come on.
You ready?
Yeah.
Top of 20. We don't expect an analysis for these.
Defendant's already emailing me asking.
You see how much you filed? You see how, on this one?
Yeah,
No,
that's the one I sent you. I know.
I know, I didn't. Well, we'll ask later. She's busy.
Bottom of 21. One arraignment populated on for today, and the 2 other ones populated for a different day.
Did you get another PR bond?
It's getting worse.
The one on Docket today is a GOP.
Okay. So 5,003 on the one on today. And then on the 2 other ones. Why would they put it on 3 different days? What the hell's, what?
It's like they were picked up on different days, like the.
Oh, I see. Okay, so it's not their fault.
The next one 6:10. Okay.
Simmer down now. Simmer down. Okay, so I guess we'll deal with the trespass when it gets here on Thursday and then.
Okay. The next one, Judge, is 22. Let me see.
Let me, real quick, let me do.
Oh, did you need to keep it at 3? 5,000. The one we're on right now.
What's?
Because I know you saw.
Yeah, so yeah, this one's gonna be 5,003. If he doesn't show up in the other one, 5,003 and then, so.
All right, let me know when you're ready.
All right, yeah, okay. Okay, who's next?
Bottom of 22.
Okay.
Richardson.
Mhm.
Fell to appear first time.
2501.
Top of 43.
Uh-huh.
Has it fell to or arraignment today, fell to appear.
But I'll send it to.
5,001. Is this the first time she's missed? Yeah, 5,001. She's got an open felon warrant.
And then 526 Turner. I was able to make contact yesterday and the mom was saying, yeah, he's not.
No? Okay, so 2501.
Mr. Character, you're up.
Okay.
Yes.
Have you been given any offers?
I'm sorry. This is simple retail theft
Okay.
allocation.
Is Mr. Carricker here?
No, sir, he's not. He's working. He was waived today.
Got it. Okay, but just let him know that, I mean, we're plea bargain deadline. If he wants to set it, great. We'll go to trial. Just no more offers after the point, though.
Yes, sir.
Yeah. Okay, cool. Discovery's complete, right?
There's some surveillance video which was tagged. The company has given a CD of it. We just need to get our hands on the actual CD.
But you have everything, though.
That should.
Have you seen everything or no?
Can I chime in, Your Honor?
Sure.
The case is 6 months old. It's a retail theft, and I have absolutely nothing disturbing aside from the body cam of the officer who detained my client in the loss prevention. So really, I'd like to get a trial if possible.
Well, no, but I'm going to give them a 10-day discovery hearing. If they don't have anything in 10 days, it's not coming in.
Okay.
It's 160 days.
The CD with the video footage was tagged and properly thrown. We just have to get our hand on the actual CD to get it up.
Nevertheless, it's 160 days. They want to set it for trial, justice delayed, justice denied. So, I mean,
Yes. And we'll get the video.
okay. You want to wait first to see if they get it, and because what if it's not there?
I'm willing to do that.
Okay, so let's do a 10-day discovery hearing. If whatever's not in, just, okay.
Maybe
For sure. You got it.
Hello, Your Honor.
Hi, Alan.
I'm here on Mr. Godfrey. What had happened, I think the state can see if they could agree to dismiss.
Oh, that's right.
So the thing is, though, I'm trying to reach his mom and his grandmother, or his aunt and his grandmother, to see if they can make the bond on the other case. I don't know that they can, so it's okay. I'm just gonna reset it if it's okay.
Yes.
I would reset it for like next Tuesday, because he's gonna be there anyway on that.
Can we do the week after?
So I do.
Works for me.
Yeah.
She's on for 7-hour cases, so do you want the Monday?
I don't care, but next week I'm gone and I'd like to see it through. That's why.
Okay.
So if we can set it the following week.
I'll tell you what, can we roll to tomorrow?
Sure.
Okay, we'll do that.
Leave that tomorrow.
Oh, can you Thursday?
Ooh, Thursday, I'm in New York, running for the parade.
Oh, wow.
My next-
Yeah, it looks like, no, but the week I'm gone.
Yeah, his felony is 7-2, so the Monday after is a
Are
holiday.
you okay with that?
That's fine with me.
Okay, yeah,
Thank you.
it's a date.
Worst case scenario, I have Mr. Booker come down, if that's okay with you.
Yeah, always. As long as they're okay with it, then I'm okay with it.
Mr. Booker represents me felons.
Oh, yeah, he'll be great.
Thank you.
Okay. All right, Ms. Garcia, you're charged with prostitution. You're facing up to 180 days in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 57 days in jail with credit for the 19 days that you've done. Thank you. You need to realize that this charge will go on your record. It will be there for the rest of your life from now on. Not only are you facing 90 days, but from now on, you may be facing a felony charge. A fourth prostitution case, you're looking at a felony offense. You understand? I'm just telling you, when you have prior criminal history, that history can use to be enhance you, and you may be very well looking at a felony offense should you pick up another one. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'll follow the agreement, sentence you to it. Good luck to you, man. Thank you, Mr. Weeks. Take care. All right, with that, we are done.